We are going to study a very famous civil rights and civil liberties case called Lawrence versus Texas. This was a Supreme Court case handed down in late June of 2003. And this case really paved the way for marriage equality in the United States, even though it was way back in 2003. So you're going to listen to actual audio of the oral argument between lawyers for Lawrence and lawyers for Texas. But before you listen to that, I wanted to provide some context and a little bit of background on the case. So this case involved a Texas law from the Texas Penal Code section 21.06. And this law made it a crime for people of the same gender to have any sort of sexual relations with one another. And the lawsuit basically said two things. Number one, this is a violation of people's privacy right to do whatever they want behind closed doors. And number two, this is singling out members of the LGBTQIA+ community for sex with one another, but not members of the opposite sex. So what's the background? The background is a famous or infamous Supreme Court case from 1986 called Bowers versus Hardwick. And Bowers versus Hardwick upheld a Georgia law that made sodomy, that was the legal term, a crime. And it upheld it and basically meant that if people were arrested for sodomy, that they could have a criminal record, could lose licenses, could not be teachers, and so forth. So this case, in addition to making the privacy and equal protection arguments, also asked the court to overturn the Bowers case from 17 years earlier. Right? The Bowers case was 1986. This case was 2003. And ultimately, as you will learn, the Supreme Court did invalidate the law. They struck it down. And they said that Bowers v. Hardwick was incorrectly decided the day that the court issued the ruling. The Supreme Court does not often say this. It does not always like to admit mistakes. And that's what made this such a momentous ruling. One of the reasons we're studying Lawrence versus Texas is it captures 4 different approaches on how to deal with unenumerated or unwritten aspects of the U.S. Constitution. So you'll see in the opinion that we link to, there are 4 different views of this. So let's start with the majority opinion. The majority opinion by Justice Anthony Kennedy says that this violated Mr. Lawrence and Mr. Garner's privacy rights. What they do in private, with consent as adults, is really their business. And basically, liberty, as understood from the U.S. Constitution's 14th Amendment and its Due Process Clause, liberty means there are things that the government cannot do. And in this case, it involved the government basically entering their apartment and arresting them for something they were doing in private. But this opinion got 5 votes, which is a majority on the Supreme Court, but not 6, even though 6 justices voted to strike it down. The other opinion is from Justice Sandra Day O'Connor. And Justice O'Connor thought the better way to strike down the law was through the Constitution's Equal Protection Clause, which is also found in the 14th Amendment. In her view, similarly situated individuals, meaning same-sex or opposite sex, should also have the freedom to do what they want. And this law basically singled out same-sex individuals for the exact same behavior that it did not single out for opposite-sex individuals. And in her view, the singling out was best addressed by the Equal Protection Clause. So those are the 6 justices that voted to strike it down. Now the dissent. The main dissent comes from Justice Antonin Scalia. And Justice Scalia basically felt that the majority was finding new rights and appointing itself as guardians of American democracy and American politics. In his view, if the state of Texas wanted to criminalize sodomy, it had the right to do so. And if anyone wanted to change constitutional rights, that what they should do is amend the Constitution through Article 5, not to asked the Supreme Court to change the Constitution. So in a way, it captures a larger question about the role of the Supreme Court and social change. Justice Scalia also accused the majority of hypocrisy because it was overturning a case that had been ruled on only 17 years before, and the court usually says that they should always uphold previous cases unless there's a really good reason to do so. In his view, the court had not provided those good reasons. Finally, Justice Clarence Thomas dissented, and he noted that he thought the law was uncommonly silly. He thought it was sort of a pointless law, and it used prosecutorial resources in a silly way. However, he reminded the nation that he was a judge and that he could not find the right to privacy in the Constitution. So as you can see, these differing views on privacy, on civil rights, on civil liberties, those are going to drive a lot of our debates and about the proper role of the court. And this affects our lives basically every single day.